All right, welcome to the deep dive. You know the drill. We grab a stack of recent info today. It's a transcript from a really great legal show covering some pretty wild courtroom stuff.
Yeah, lots happening.
And our mission, as always, is to unpack the key bits, the important insights from these sources, help you get informed quickly, give you those memorable details, you know?
Make it stick, absolutely. We've got quite a range today. High-stakes capital cases, alleged misconduct, some fundamental court principles playing out.
Okay, let's jump right in then. First up, the Bryan Kohberger case. There's some interesting procedural news. Witnesses in Pennsylvania.
That's right, and this process, honestly, it's usually a real pain in the butt.
Why is that? If the witness is out of state?
Well, yeah. If you've got someone in Pennsylvania, but the trial's in Idaho, the Idaho court, it doesn't just automatically have power over that person way over in PA.
So Idaho can't just, like, send a subpoena and force them to come?
Not to compel them, no. Not unless the witness just agrees, comes voluntarily, maybe signs something. But if you need to make them come.
You need a formal process.
Exactly. It's a whole thing. You get this subpoena from Idaho, then you got to find a local lawyer or prosecutor in Pennsylvania.
Okay.
They have to get it on the court docket there, serve the person formally, get them into a PA court, and then that Pennsylvania court has to actually order the person to travel to Idaho.
Wow. So it's not just sending a piece of paper. It's like this whole multi-state legal dance.
Pretty much. A multi-step thing, 2 different court systems involved. And look, if you skip that formal process and the witness just blows it off,
You're stuck.
you're stuck. No contempt, nothing. You're just out of luck. And then down the line, if your client gets convicted, they might claim ineffective counsel because you didn't compel that key witness.
Ah, okay. So you kind of have to do it this way for important witnesses, even if you hope they'll just cooperate.
You really do. It covers your bases.
Makes sense. So who are these 5 people the source mentions? Subpoenaed in PA for a hearing, June 30th, 2025.
Yeah, the list includes a Michelle Bulger. She's a professor at Dalhousie University, taught Kohberger in his master's program. Criminology, I think.
Oh, I remember her. She called him a brilliant student or something and was shocked.
That's the one. That quote definitely got attention. Also, Ann Parman, an advisor at Dalhousie. Then Jesse Harris, who worked at a boxing gym where Kohberger apparently trained daily. That came from a 2015 job application note.
A boxing gym employee. Huh. That's specific. How does that play in, potentially?
Well, the filings don't say. Could be about his physical condition, habits, maybe interactions around that time. It's unclear from the source.
Okay.
And the last 2 names are Ralph Faceto and Maggie Sanders. Again, no details in the filings about their connection. Bit of a mystery there.
And do we know if these are for the prosecution or the defense?
For Faceto and Sanders, no. It doesn't specify.
Yeah.
But given, the professor, the advisor, it feels like most, maybe all, are likely mitigation witnesses for the defense.
Right, for the sentencing phase, if
Yeah.
it gets there, to talk about his background, character.
Exactly.
Got it. And just quick context for anyone catching up. The main evidence we hear about against Kohberger, it's the DNA on that knife sheath button, right? Found under one victim, Madison Mogan.
Yep, that's key. Plus the cell phone data, putting his phone near the house multiple times beforehand, and the surveillance video of a car like his leaving the area.
Arrested December 30th, 2022 in PA, facing the death penalty if convicted.
Okay.
That's the situation. And the defense has been busy filing motions. They filed a sealed amended mitigation witness list, and importantly, a motion to present alternate suspect evidence. That came up back in an April 2025 hearing.
And his lead lawyer said they have a lead on someone else from police tips.
That's what the source says. And their theory is pretty specific. They're suggesting Kohberger's DNA might have been planted.
Planted? Wow.
Yeah, planted by the, quote, real killer. And they're also suggesting 2 killers were involved using the weapon.
2 killers. Oh,
They
sorry.
submitted evidence supporting this on May 23rd. Prosecution response was due. Well, today, June 6th. Okay, now this is where it gets really interesting. Alternate suspect theories. How hard is it to actually get that stuff into court? Can the defense just, point fingers?
Oh, no. It's tough. Really tough. The standard's pretty high. You generally have to show the cops should have arrested this other person. There's real evidence pointing to them.
Not just a random idea.
Right. It has to be more than a hunch. Or just saying, hey, this other person existed. You need something connecting them to the crime scene, the act itself. Unless, they're saying the alternate suspect worked with Kohberger. But usually it's about deflecting blame.
So you're skeptical?
Honestly. Based on this in general practice, yeah, I'd be skeptical. Plus, the judge in this case hasn't issued a warrant for anyone else, right? That tells you something.
Good point. But let's say the judge does allow it. What's the potential impact then?
Oh, huge. If that theory gets admitted, it could be massive. The defense doesn't have to prove the other guy did it. They just need one juror to think, maybe. Create that reasonable doubt about Kohberger.
Could lead to a hung jury, or even acquittal.
Absolutely. It's a high-stakes move for sure.
Okay, another twist. The request for a delay because of that Dateline episode.
Yeah, that caused a stir. The defense argued it leaked sensitive stuff. Kohberger's phone records, online searches, even surveillance footage that hadn't been public.
Things not yet seen in court, or maybe even by the defense fully?
Potentially, yes.
Yeah.
Details that shouldn't have been out there yet.
And the judge's reaction, I heard, not amused.
Yeah, not amused is putting it mildly, based on the description. The judge issued a pretty stern order. Basically said someone close to the case likely violated the gag order.
Okay.
And didn't just warn them. Started an investigation to find the leak. Ordered both sides to save all their records, name everyone who had access to this leaked info.
Wow. Taking it very seriously. So a leak like that, how does it mess with finding an impartial jury, practically speaking?
It just taints the pool. You know, jurors are supposed to decide based only on what they hear in court. But if millions saw stuff on TV, stuff that might not even be admissible evidence.
They might already have opinions, even subconsciously.
Exactly. It gets incredibly hard to find 12 people who haven't been influenced or who can truly set aside what they saw or heard outside the courtroom. The judge clearly saw it as a major threat to a fair trial.
Makes total sense. So that June 30th hearing sounds like a big one.
It really does. Ruling on the alternate suspect evidence is expected then, too. That could change the whole shape of the trial.
And just quickly, something about sealed records from March. Access was granted.
Yeah, someone got court permission to see some sealed records from March 5th, 2025. But they're still sealed for the public.
Huh. Makes you wonder who got access and why they're still sealed if someone saw them.
It does raise questions, yeah. A little bit of procedural mystery there.
So what's the takeaway from all this Kohberger stuff for someone following along?
I think it really shows you the nitty-gritty, sometimes frustrating steps in a huge trial like this, the procedural battles, and you see the intense strategy fights between prosecution and defense over evidence. What gets in, what stays out, and maybe most importantly, how much media attention can complicate things, especially finding that impartial jury.
It's definitely complex. Every little step matters.
Yeah, the procedure itself is often a huge part of the battle.
Okay, fascinating. Let's switch gears now. The Karen Reed case, day 28, and a cross-examination described as a masterclass.
That's the one. The source really highlighted the cross-exam of Dr. Wolf. He's the accident reconstruction director at RCA. Defense attorney Hank Brennan did the cross.
Okay, so remind us, what did Dr. Wolf basically say on direct?
Well, Dr. Wolf testified his analysis showed the damage on Karen Reed's SUV tailgate. It was consistent with being hit by a drinking glass. Yeah. Not consistent in his view with hitting a pedestrian like John O'Keefe. He had a whole report testified before. And he was critical of the prosecution's expert too, Dr. Welcher. Said his tests were very basic, didn't answer key questions about the taillight or O'Keefe's injuries. Source says the jurors were paying close attention, taking notes.
And RCA, his company, they did their own tests with a Lexus and a dummy.
Yeah, they did control tests, vehicle-pedestrian interactions, showed video of a taillight hitting a crash test dummy to simulate it, tested speeds from like 15 up to 29 miles per hour.
And his conclusion?
He concluded the damage on Reed's car was inconsistent with the dummy tests at all speeds. Said at higher speeds, like 29 miles per hour, the test vehicle got more damage than Reed's car had. And crucially, he testified the taillight pieces in their tests. They didn't puncture or fray the dummy's hoodie sleeve.
Which is different from what was described for O'Keefe's clothing.
Right. He said the dummy sweatshirt showed clearly road rash, which he argued was inconsistent with O'Keefe's sweatshirt as he understood the injuries.
Okay. And how did RCA get paid for all this work?
Dr. Wolf confirmed they got $20,000 after the 2024 trial. That was for travel and testimony time, separate from the initial report cost. And they also got $50,000 from an outside agency.
An outside agency, not the defense or prosecution directly.
Apparently not. The prep notes mentioned DOJ, possibly, but in court, he just said outside agency. That was the term allowed.
Interesting, they couldn't name the agency. Why hide that?
Could be rules of evidence. Maybe the defense didn't want the jury thinking a big federal agency backed the findings, you know.
Yeah.
could give it undue weight before they assess the science themselves.
Right. Keep the focus on the methodology, not who paid initially.
Exactly.
Right.
Beyond just establishing they were paid to explore bias.
Okay, so on to the cross-examination by Hank Brennan. What made it a master class? What did he focus on?
Brennan hit several things. Questioned Wolf's credentials, certification testing, tried to establish RRCA works for insurance companies a lot, maybe implying a bias towards analyzing vehicle damage over pedestrian impacts, even though this outside agency hired them first. Then a big one. Dr. Wolf deleting text messages with the defense team.
Whoa, why?
Wolf said he routinely deletes logistical texts, scheduling stuff, so they aren't normally kept.
But Brennan probably made it sound suspicious.
Oh, yeah. And he pointed out they used Signal, the encrypted app. Wolf confirmed Signal doesn't keep records by default, and he agreed to use it because the defense asked him to.
So Brennan could suggest they chose it to avoid leaving a trail.
Exactly. Plant that seed.
Yeah.
Brennan also went after this question list and answer notes thing provided to the defense, called it a script.
A script for his testimony.
That's what Brennan implied. Wolf pushed back hard, called it an outline to help explain complex science, Said it didn't change his analysis at all.
Okay, what else? Anything about the dummy itself?
Yeah. Brennan brought up a report by Wolf's colleague, Dr. Rentschler, about whether crash test dummies are good for looking at specific things like clothing tears or skin abrasions.
And did Wolf know about it?
Wolf said he'd read the report, yeah, but admitted he hadn't personally reviewed every single source his colleague cited. Relied on the colleague saying the dummy arm was okay for analyzing arm injuries like O'Keefe's.
Okay.
Then Brennan hit him with the big one, the weight difference. Said the dummy's arm weighed 9.38 pounds, but O'Keefe's arm, Brennan stated it weighed 11.86 pounds.
That's, what, over 26% heavier? Is that difference significant? Does it matter with a huge SUV?
Well, Wolf initially said, with a 6,000-pound vehicle, that specific difference wouldn't really change the damage much in field tests. Tried to downplay it.
But Brennan pushed back.
He kept hammering on it,
Yeah.
highlighting how controlled tests aren't the same as a chaotic real-world event.
Yeah.
And under that pressure, Wolf eventually conceded.
Yeah, if the weight difference is significant, it can matter.
So he admitted a potential flaw, that the dummy arm wasn't a perfect match and it could affect the results. That's basically how it came across, yeah. Wolf tried to hold his ground, but Brennan forced that confession about the 26.3% difference. That yes, it can matter. It was definitely a moment where the expert had to admit a limitation, even if he tried to minimize it.
What happened on redirect? Did the defense try to fix it?
Jackson, on redirect, played that 24-mile-per-hour test video again. Wolf confirmed the dummy had clear road rash, repeated it was inconsistent with O'Keefe's sweatshirt. Jackson also got Wolf to confirm RCA wasn't hired by insurance initially, and that Wolf didn't know where Brennan got that 11.86-pound number for the arm. No one from RCA weighed O'Keefe's arm.
So your takeaway from this cross, did it live up to masterclass? What was the impact?
I'd say, based on the description,
Mhm.
Yeah, it sounds like Brennan was methodical, chipping away. And honestly, my read is Brennan probably scored more points with the prosecution with that cross than the defense maybe got from Wolf's direct.
Really? How so?
By the end, Wolf seemed kind of pushed into conceding his tests could still be consistent with the car hitting someone, and that the methodology, especially that arm weight thing, had flaws. Wolf definitely fought him, but Brennan's persistence, especially on the weight, getting that it can matter admission, that was effective.
So Brennan got close to making the jury doubt the whole test disproves it angle.
Pretty much as close as you could get, I think, without Wolf just flipping his testimony. Made the jury question if the test really ruled it out.
Definitely shows how complex expert testimony gets picked apart.
Oh, absolutely. It's a great example of how cross-examination works. Not just to confuse, but like that quote we'll get to, testing the veracity, trying to elicit truth, shows the fight over how science gets interpreted.
Perfect segue to our next topic. Law enforcement accountability. The sheriff in Osceola County, Florida.
Yeah, a really disturbing story out of Florida. Sheriff Marcos Lopez, arrested. Serious charge.
Racketeering and conspiracy. For a sitting sheriff. That's huge.
It is. First-degree felonies. They're alleging he orchestrated this sprawling illegal gambling operation. Generated, get this, $21.6 million.
Wait, $21.6 million from illegal gambling, allegedly run or protected by the sheriff. How does something that big even operate?
That's the shocking part, right? He was elected in 2021, re-elected just in 2024. Even though his time in office was already marred by controversy, there was that 2022 civil rights lawsuit. Deputies tackled a guy at a gas station, caused severe burns.
Right, I remember hearing about that.
So This gambling investigation started in 2023, uncovered what they call a sophisticated gambling network. And the allegation is Lopez had a multifaceted role, protecting it, helping it grow, and personally benefiting. Campaign money, secret payments.
Wow. Florida's Attorney General called it a solemn day.
Yep. Ashley Moody?
Yeah.
Said it was a solemn day for Florida and our law enforcement community. Emphasized public servants shouldn't exploit trust like that. There's apparently video of agents approaching Lopez before the arrest. And he asks, What is this about? Then he gets cuffed.
And Governor DeSantis stepped in immediately.
He did. Executive order. Suspended Lopez from office. Appointed an interim sheriff, Christopher Blackman, 35-year veteran from the Highway Patrol.
What's next for Lopez? Legally speaking?
Booked into jail, no bond. Arraignment set for June 30th. If he's convicted on these charges, he's looking at multiple decades in prison.
And the reaction locally, strong criticism mentioned in the source.
Yeah, pretty harsh. Polk County Sheriff Grady Judd said Lopez embarrassed himself, his family, the great men and women at his own office. A commissioner said law enforcement are held to higher standards. The lawyers from that 2022 burn incident lawsuit. They put out a statement saying the arrest shows a deeply rooted culture of unlawful behavior, starting at the top. Community leaders called it unsettling, disturbing.
It really is deeply disturbing when you're sworn to uphold the law and then accused of running a massive criminal operation.
It really gets at the core principle, doesn't it? Public servants, especially law enforcement, are held to a higher standard.
Yeah.
You take that job, you know the trust involved, the responsibility. If you break that trust, the consequences have to reflect that. Arguably more so than for just, an average person.
Yeah.
I remember I represented a deputy once smuggling contraband into a jail.
Oh, wow.
Yeah. And I made my arguments, about his background, danger in prison, all that. And the judge, a really good judge, just looked at my client and said, son, you had a badge and you spit on it.
Oof. That's powerful.
It was. Gave him the max sentence. And I understood it.
Mm-hmm.
My job was to represent him. But I totally got why the judge felt that message was necessary. If you choose that work, you know the deal. Betraying that trust, especially for money, the system has to come down hard.
This case definitely throws a harsh light on public trust and accountability at the highest levels.
Absolutely. A critical reminder about accountability within the system itself.
Okay, let's pivot now to maybe less serious in scale, perhaps, but still cautionary, or just bizarre, our dumb criminals segment.
But first one, Indiana man, online danger.
This one is just, weird and gross. James A. Rabber, 63 years old. Police set up a fake Facebook profile, posing as a 13-year-old girl.
And according to the affidavit the source mentions, Rabber allegedly sent just an abundance of sexual explicit messages.
Yeah.
Asked how the girl could hide out with him in a safe country. Got jealous, apparently, asking if she was with another man. Offered to pick her up, take her to Florida, but only after she performed various sex acts.
And then there's that quote, the really, really bizarre SpongeBob thing.
Yeah. Allegedly described himself as very big, tall guy, 6'4", 295, built like SpongeBob, and then added, a vulgar promise.
Yeah.
If you've ever had a fantasy about effing SpongeBob, that's me.
I have no words. Weird, creepy, gross. Beyond the obvious creep factor, does describing himself like that actually help prosecutors? Does it show intent or maybe just delusion?
It definitely paints a picture, right? Not just intent, but maybe. A real disconnect from reality. Like the source says, you're 63. A 13-year-old is your granddaughter's age. The idea any teen fantasizes about that.
Wow.
It says a lot about his mindset, why he targets kids. It's deeply disturbing.
They set up a meeting.
Yep, at a village pantry. When the detective, posing as the girl, said she might have trouble leaving, Rabber allegedly messaged, WTF, that really screws me driving there today.
Yeah.
And told her not to walk to a nearby bar because of cameras there.
Which kind of helped confirm it was him and he was planning to show up.
Ironically, yes.
Yeah.
Police were waiting, arrested him. He apparently confirmed it was his account, his conversation, vehicle matched.
And he has a prior record.
Source says extensive criminal history, but mostly DUI, traffic stuff. Nothing like this, obviously.
So the takeaway, besides the horror?
Well, the source calls him dumb criminal of the day, which fits trying to meet a minor online. But the real lesson, as the source bluntly puts it, if you're 63 and a kid online agrees to meet you, it's probably a cop.
Yeah. Good point.
Just date people your own age. Or at least make sure they're 18, check ID. Though even that, as the source notes, still feels weird and creepy to most people.
Underlined by a truly awful example. Okay, next, dumb criminal. DoorDash driver and a tip. Or lack thereof.
Yes.
Yeah.
Robert Dellenhall, Vancouver, Washington, apparently got mad he didn't get a cash tip on a $100 delivery. So he went back to the house.
Went back to demand a tip?
Yes.
Seriously?
According to the source, yeah.
Yeah.
Showed up demanding a tip like a mobster, being loud and mouthy.
Okay. And when they told him to leave?
He escalated big time, allegedly reached for a holster and a Ruger firearm.
Pulled a GUN over a tip? That's insane.
Completely nuts. But the resident, Anthony Volino, didn't freeze, smelled liquor on the guy, saw the danger, and just went for it. Grabbed the gun, shoved Dellenhall. They ended up wrestling over it, like backyard wrestling.
Yeah.
Volino got the gun away, sent Dellenhall sprawling.
And this was caught on camera?
Yep. Source mentions home security footage showing the struggle.
What did Dellenhall do after getting disarmed and decked?
This is the other bizarre part.
Yeah.
He leaves, gets in his car, and calls 911 himself. Tries to spin it.
He called the cop yes after pulling a gun.
Yeah. Claimed the house cheated me out of a tip. Said he was pushed. Trying to play the victim.
Is that common? Criminals calling the cops first to try and control the story?
It happens more than you'd think. Maybe not usually after pulling a gun, but yeah, trying to get their version in first. Didn't work here, though. Cops smelled liquor, tested him, way over the limit. More than twice.
Did he admit anything?
Source says he told the officers, "I shouldn't have come back." Described as a rare moment of clarity.
Charges.
Assault, harassment, DUI, and yeah, his DoorDash career. Over.
Lesson learned. Besides the obvious, don't be an idiot.
Don't chase tips with a loaded gun while drunk. Leave the drama to TV. Definitely another dumb criminal of the day. Mentally, right there with the SpongeBob guy.
Yeah.
These stories, kind of funny in a dark way, but really just cautionary tales about bad judgment, entitlement, and unexpected risks.
They absolutely highlight those strange, sometimes dangerous consequences, poor decisions, entitlement, online risks. Vivid cautionary tales for sure.
Yes, stark reminders of what can happen when judgment just completely fails, online or off.
Okay, to wrap things up today, let's touch on some legal history. And a quote, what's notable about June 6th?
Well, several things in U.S. legal history. June 6, 1788, Virginia was deep in debate over ratifying the Constitution. That whole process shaped the federal judiciary. Laws like treason, fundamental stuff.
Okay.
Then June 6, 1934. DOJ names John Dillinger public enemy, #1. Big moment for federal law enforcement, focusing on organized crime.
And civil rights-related events.
Yes. June 6, 1963. JFK gives that televised address, urging equal treatment for all Americans, really laid groundwork for the Civil Rights Acts. And more recently, June 6, 2012, a federal judge rules the Defense of Marriage Act unconstitutional. Big step for marriage equality.
Important moments showing how the legal system evolves, grapples with things. And since we talked about that Karen Reed cross-examination, what's the legal quote for today?
Fittingly, yeah. The purpose of cross-examination is not to create doubt, but to elicit truth. It is a tool to test the veracity of testimony, not merely to undermine it.
That really hits the nail on the head, doesn't it? What you were saying about Brennan pushing Dr. Wolf for concessions, not just trying to confuse things,
Right.
Testing the information.
Exactly. It highlights that ideal function. It's supposed to be about truth-seeking, not just, hiding the ball. Like the source notes, if the prosecution laid out the whole truth perfectly on direct,
Yeah.
maybe you wouldn't need such long cross-exams.
Right.
The Supreme Court itself called cross-examination the greatest truth-seeking tool ever invented under the Sixth Amendment. And, you can often tell how well direct went by how long the cross is. If cross goes on forever, maybe direct didn't get the whole story out clearly.
That's a really interesting point. Ties these big principles right back to the courtroom examples we just looked at.
Yeah, it connects the history and the theory to how it's supposed to work in practice, even with all the strategy and human factors.
Well, we've definitely covered a lot of ground in this deep dive. From those complex procedural steps in a capital case, the battles over experts.
To the really shocking alleged misconduct by that sheriff and those, let's call them unique cautionary tales.
Right. Understanding these details really does give you valuable insight, doesn't it, into the complexities, the human side of the justice system.
It really does, at every level.
Absolutely. So as we wrap up, here's a final thought for you, building on all this. We see these intense strategic battles in court over evidence, perception, rules, given that adversarial system. How close do you think the process actually gets to finding some kind of absolute objective truth? Or is it more about reaching a verdict based on what can be effectively proven and argued within those specific courtroom limits?
That's a fundamental question, isn't it? That tension between truth-seeking and the adversarial process. Definitely something worth thinking about.
Keep questioning, keep exploring. That's all for today's deep dive.